Hello and welcome to this Deakin University alumni webinar presented by Dr. Marilyn McMahon. Sam Johnston here from the Deakin Alumni Relations team. It's great to have you with us. I'd like to start by acknowledging the traditional owners of the land from which we're broadcasting today, the Wurundjeri people of the Kulin Nations, and to pay our respects to their elders, past, present and emerging. Today we're broadcasting from Deakin's Burwood campus and our webinar topic is Bail or Jail, how locking up legally innocent people is straining Victoria's prisons. To watch past webinar and seminar recordings, visit the webinar and resources page on the Deakin alumni website. Today's webinar will be recorded and posted online and will be available in approximately 3 weeks under the Faculty of Business and Law section of the page. Our presenter today, Dr. Marilyn McMahon, is a professor and the Deputy Dean at Deakin Law School. She graduated from the University of Melbourne with a Bachelor of Arts honours and a Bachelor of Laws, obtained a Master of Psychology Forensic from Monash University and was awarded a PhD with distinction from La Trobe University. Her research is primarily in the areas of criminal law, criminal procedure and evidence. Thank you so much for joining us today, Marilyn.
Thanks, Sam. Before commencing today, I would like to express my gratitude for being awarded the Victorian Parliamentary Library Fellowship in 2018 and for the considerable assistance that was provided to me by the staff of the Parliamentary Library and Information Service. This really lies behind my project investigating bail in Victoria. The case of Ratu Bose, a man who was charged with rape by police, then released back into the community on bail, and who then committed another rape while on bail before his trial for the first rape, captures the problem that has attracted so much attention in recent years: serious crimes being committed by people who've been charged with offences, who've been released back into the community on bail before their trial, and who then commit serious offences while out on bail. There's a real sense that these crimes could have been prevented if bail had been denied. But there's another side to this problem. Lock up too many people because you fear they will commit a serious crime if you release them on bail, and you create another problem by overloading your prison system. And this is what is currently happening in Victoria. At the end of October 2019, of the 8,026 people in prison in Victoria, nearly 2,000 had not been sentenced. This constitutes over 1/3 of the Victorian adult prison population. We have more people unsentenced in Victoria, that is, people presumed to be legally innocent in 2019, than we had convicted prisoners in 2005. And this is driven by the increase in the number of people who are being denied bail. Moreover, these figures represent the culmination of a trend that has been occurring in Victoria and elsewhere in Australia for nearly 2 decades. With an estimated current daily cost of nearly $1 million, detaining these people in prison, those who've been denied bail, before the hearing of their cases is costly. While broadly similar to other jurisdictions in Australia, the position in Victoria contrasts sharply with that in England and Wales, for example, where those held on remand comprise only 10% of the adult prison population. Looking at this graph tells the story. Unsentenced prisoners, those who are denied bail, are an ever-increasing proportion of our prison population. They are driving up the number of people in Victorian prisons, leading to overcrowding in our existing jails and a seemingly never-ending call for new prisons to be built. This increase is not inevitable. 20 years ago, England and Wales had a similar proportion of people in prison who'd been denied bail and were being held in prison on remand, similar to Victoria. But today, Victoria has nearly 4 times more prisoners in this category than England and Wales. Why this difference? My research led me to identify growing concern in Victoria about community protection, a concern about offences committed by persons released on bail, which has led to restrictive laws and practices seeing more and more people being detained before their trials. But as we are seeing, this comes at a cost. So in my research, I'm investigating how we can protect the community without significantly increasing the number of people who are denied bail and detained in prison before their trial or hearing. I've identified some strategies that I think can satisfy these twin goals, and I'll be talking about those later. I also had other concerns. Somewhere along the way, we've lost sight of the legal issues involved in bail. As has been pointed out many times, detaining people in prison before they have been tried and convicted of an offence challenges the foundational right to liberty and the presumption of innocence, imposes significant adverse consequences on those detained, possible loss of employment, separation from families, a reduced ability to prepare for legal proceedings, and exposure to the dangers of a prison environment. It also presents multiple linked legal disadvantages. Pre-trial imprisonment is associated with an increased likelihood of pleading guilty, being more likely to be found guilty, and being given a custodial sentence. It also imprisons some people who will subsequently be found not guilty, or, if convicted, will be given a non-custodial sentence. The New South Wales Law Reform Commission reported a study that found that at the local or magistrates court level, 42% of those on remand at the time of the hearing of their case were either found not guilty or given a non-custodial sentence. These individuals received no compensation for the time they'd spent in prison. And there are other issues. The frequency of remand is gendered, with higher rates for women. In the middle of 2019, nearly half, 46%, of the women incarcerated in Victoria were being held on remand, compared with 36% of male prisoners. Interestingly, just over half of these women did not even apply for bail. Their most common alleged offences were not violent crimes, but property, drug and burglary offences. Pre-trial imprisonment also contributes to the incarceration crisis with Indigenous offenders. Nearly 20 years ago, the Royal Commission into Aboriginal Deaths in Custody found that more Aboriginal people had died while on remand than had died while serving a sentence. More recently, the National Congress of Australia's First Peoples identified that bail laws contributed to the overrepresentation of Aboriginal and Torres Strait Islander people in Australian prisons through the overuse and abuse of remand, particularly for low-level non-violent offences. How have we got to this position? To answer that question, I looked at the history of bail law in Victoria and how it has been transformed in recent years. Prior to the enactment of our first Bail Act in Victoria in 1977, it appears that few people on remand were detained specifically because of concerns about community safety. When the Bail Act was enacted, it entrenched the presumption that people would be presumed innocent and would be granted bail, and identified 4 risk factors that had to be taken into consideration when deciding whether a person would be granted bail. A decision maker was required to consider whether there was an unacceptable risk that the person applying for bail would attend court for the hearing of their matter. That's always been the traditional, conventional concern with bail. Second one was commit an offence while on bail. Third was endanger the safety or welfare of members of the public. Or the fourth concern was that the person would interfere with witnesses or otherwise obstruct the course of justice if they were granted bail. Concern that a person would commit an offence if released on bail or endanger the safety or welfare of members of the public gradually fused into concern about what's being called community safety and the need for community protection. This consideration was not prominent in early parliamentary discussions of bail. Indeed, in the late 1970s, concern was more likely to be expressed about the rights of the accused and police opposing bail on far too many occasions. On the specific issue of the risk of offending by people on bail, the then Attorney-General stated that it was not easy to determine how many offences were committed by people on bail, but they'd observed that although this does happen from time to time, in the majority of cases it does not. That was in 1977. However, concern about community protection did lead to one unusual risk management strategy being adopted. For a very small number of offences, aggravated burglary, offences that involved the use of a weapon, or where the accused was charged with certain offences while already on bail, a reverse onus test was introduced. In these circumstances, the person applying for bail had to show cause why bail should be granted. Within a few years, an even more restrictive test applied to those charged with murder or treason. They had to show exceptional circumstances why they should be granted bail. These unusual risk management tests effectively remove the presumption of innocence and place the onus, reverse the onus for getting bail, on the applicant to satisfy the bail decision maker as to why they should be released on bail. This began a process that has become increasingly important in using bail as a site of crime prevention and community protection. However, for the first 2 decades after the introduction of the Bail Act in 1977, the vast majority of people were granted bail, and the proportion of the prison population being held on remand was relatively constrained. In 1998, it amounted to about 15% of adult prisoners. But in the following 2 decades, as concerns about community protection grew, the provisions of the Bail Act were repeatedly amended and became increasingly restrictive. The use of reverse onus provisions as a risk management strategy increased. Accompanying these changes, the proportion of unsentenced prisoners more than doubled over this period. Importantly, some developments from 2012 onwards massively heightened concerns about community protection. 3 heinous crimes committed by men who'd been released on bail attracted enormous public attention. In 2012, Adrian Bailey raped and murdered Jill Meagher while on bail. In 2015, Sean Price murdered Mara Vukotic while on bail and under a supervision order. In 2017, James Gargasoulis went on his rampage in Bourke Street, Melbourne, and killed many people. Community protection now dominates all concerns about bail. The Victorian government responded to these concerns in 2017 by commissioning the Honourable Paul Coghlan to review the operation of bail laws and practice in Victoria with the key aim of best managing risk and maximising community safety. The Coghlan review ultimately contained 37 recommendations for reform. These favoured maintaining the presumption of bail, but extending the reverse onus tests to apply to a much larger range of offences. The review acknowledged that this extension was inconsistent with the presumption of innocence and the right to liberty, but justified it on the basis that the community favoured such an extension because it would enhance community protection. Justice Coghlan also considered that greater emphasis should be placed on the assessment of risk and that reforms must recalibrate the balancing of the rights of the individual against those of the community to clearly favour community protection. The Victorian government accepted most of the recommendations, which were also endorsed by the opposition. Community protection dominated the parliamentary debates and media reporting associated with these reforms in 2017 and 2018. These debates overwhelmingly focused on the risk of future offending by those applying for bail and relied on refusal of bail and remand, that is imprisonment, as the appropriate strategy for risk management. There was increased focus on violent crimes such as rape, murder, gang violence, carjackings, home invasions and individual assaults committed against members of the community, with most of those being high-profile crimes but occurring relatively infrequently. Compared with parliamentary debates in 1977, in 2017 and 18 there was less concern with the rights of bail applicants. There were fewer references to principles such as the right to liberty and the presumption of innocence. Changes made to the Bail Act in 2017 and 2018 now make community protection the primary risk consideration in all bail matters, by specifying that all decision-making in relation to bail should recognise the importance of, quote, maximising the safety of the community and persons affected by crime to the greatest extent possible. That's in one of our guiding principles. Other guiding principles only have to be taken into account or recognised as promoting certain values. Community protection is the benchmark. The two-step process, which I've previously described, applying to some bail applicants involving those reverse onus tests, has been entrenched, although show cause has now been replaced by a matter called show compelling reason. You can see the significant changes that have occurred by reference to the slide. In 1977, we had an entrenched right to bail. There was concern about remanding people into prison, the conditions that they would experience. There was almost no concern about offences being committed by people who were released on bail. And we had a relatively constrained number or proportion of prisoners being held on remand. If we contrast that with the present situation, you'll see that community protection now dominates parliamentary debates and media discussion of bail. There's been a huge increase in what's called the reverse onus offences. That's the two-step process whereby the onus comes on the bail applicant to justify why they should be granted bail. And generally, risk assessment and concerns about risk permeate our criminal justice system. This has resulted in currently more than a third of adult prisoners in Victoria being unsentenced, being people who have been held there on remand because they've been denied bail. This has also led to a complex process in relation to bail decision-making. Recent reforms consolidated that two-step process in relation to bail. First, for less serious offences, a one-step process is involved. If bail is to be denied here, the prosecution must establish that if the applicant was released on bail, there would be an unacceptable risk that she or he would not turn up at court for the hearing of their case, would offend while on bail, would endanger the safety or welfare of another person, or would interfere with the course of justice. Note that the onus there is on the prosecution to establish those things, and we have a presumption of bail. However, for more serious offences, that two-step process is involved. In the first step, the person applying for bail has the onus themselves of showing that they should not be detained in custody, either through showing exceptional circumstances or showing compelling reason why they should be granted bail. If they satisfy this step, in the second step, the prosecution can still get bail denied if unacceptable risk is established. In both steps, the same 31 circumstances surrounding the offence must be considered. They are identified in the Bail Act and include matters such as the nature and seriousness of the offence with which the person is charged, their criminal history, their background and character, etc. No guidance is provided to how these many factors should be evaluated. So if we look at the current situation, what we've seen as an enormous growth in the reverse onus offences, starting in the 1970s with those very serious offences, treason, murder, then aggravated burglary, indictable offence with a weapon against the Bail Act. What we've seen in the subsequent years is a massive increase in the number of offences where the onus on getting bail is put back onto the applicant. What we saw, although that two-step process in the original version of the Bail Act in 1977 only applied to a handful of cases, it now applies to more than 100 offences. Consequently, while the framework established by bail law remains essentially the same as that established 40 years ago, Victorian bail law has been amended so significantly and had so many offences added to the reverse onus tests that the presumption of a right to bail no longer operates for more than 100 offences. No other jurisdiction in Australia has the presumption of bail hedged in by so many exceptions. Unsurprisingly, it is generally acknowledged that Victoria now has the most restrictive regime governing bail in Australia. When introducing the recent reforms, the Attorney-General observed that the overhaul of the bail system would improve community safety by making it harder than ever for people to get bail. And that has certainly proved to be true. As previously noted, more than 1 in 3 people currently in jail in Victoria is there on remand, that is, there because they've been denied bail. But have we drawn the net of remand and imprisonment too widely? Are we imprisoning too many people because of our fear of crime? What does research tell us about crimes committed by people on bail? The crimes committed by Adrian Bailey, Sean Price and James Gargasoulis have driven a belief that serious offending by persons released on bail is common. This view seems to be held by people in the community and has certainly driven recent policy and law reform. But how common is serious offending by people on bail? The few studies that have been conducted in Australia and elsewhere suggest that most persons are not charged with an offence while they are on bail. If you look at the studies summarised on this slide and covered in more detail in my parliamentary research paper, studies based on research in Australia, England, Scotland, the United States and New Zealand, the central number in each figure indicates the percentage of persons who committed an offence while on bail. You can see that this varies from 17% to 29%, indicating that most people do not commit offences while on bail. Also very significant, most of the offending that did occur involved non-violent offences. Only a much smaller proportion involved serious violent offences such as murder, sexual offences, robbery, etc. This is not to dismiss the problems caused by those who commit serious offences while on bail. However, it does suggest that risk assessment must be more specifically targeted to identify the relatively small group who commit serious offences, and that the reverse onus provisions, based solely on the offence with which the person is charged, over-predict risk. And there is also one further very troubling consideration. Imprisoning people before their trial has serious adverse consequences in terms of their likelihood of committing crimes in the future. Denying bail as a means of community protection may offer some short-term benefits, but what is particularly concerning are the long-term or downstream effects of this strategy. Important research recently reported in the United States suggests that even short-term pre-trial imprisonment contributes to later offending. Thus, a study of persons in Texas compared 2 matched groups of people who had been arrested and charged with criminal offences. One group was granted bail and the other held on remand in prison. During an 18-month follow-up period, those who had previously been remanded into prison were more likely to be charged with future offences. Pre-trial imprisonment was associated, in fact, with a 30% increase in later serious felony charges and a 20% increase in new minor misdemeanour charges. Another study, using data from Florida and Pennsylvania, adopted a different methodology and reached a similar conclusion. Pre-trial imprisonment is associated with an increased likelihood of long-term criminal offending. This evidence suggests that pre-trial imprisonment may itself have a criminogenic effect. Paradoxically, the protective benefits of short-term pre-trial imprisonment may ultimately compromise community safety. Given that most of those released on bail do not offend, and that imprisoning people before their trial is itself criminogenic, how do we more precisely target those who are likely to offend if released on bail? One promising strategy is to use actuarial scales such as those beginning to be used in some reforming jurisdictions in the United States, such as this one, the Public Safety Assessment Scale. On the public safety assessment scale, a person who applies for bail is assessed on specified criteria and given a score. This score is then used to identify the level of risk if they were released on bail. The PSA scale assesses people applying for bail on 9 risk factors. They then obtain 3 scores: failure to appear, new criminal activity, and new violent criminal activity. The last scale is particularly relevant for our discussion today, as it expressly goes to the issue of community protection. The matters in the PSA scale must already be taken into consideration by bail decision makers in Victoria. The scale simply selectively utilises and weighs a small number of these factors that have been empirically identified as most likely to accurately predict risk. So, how do we improve the current situation? How do we protect the community and reduce our remand population? Strategies for reform. Currently, assessing the risk that a person will commit an offence if they are granted bail is unnecessarily complex and also results in too many people being denied bail and remanded into custody. 3 reforms could simplify bail decision-making, improve risk assessment, and serve the twin goals of protecting the community while reducing the number of persons held in our prisons. These 3 reforms are: first, removing some offences from the category of bailable offences. Although I have focused on risk assessment relating to serious offending, a significant pragmatic strategy for reducing the number of persons held on remand would be to remove some relatively minor non-violent offences from any requirement of bail. In effect, this reform involves an assessment that the minor nature of the offending fails to raise concerns about community protection and other risks. This approach has been adopted in England, where for minor offences someone might get something akin to what we know as a parking ticket or similar, rather than being arrested and then being granted bail. In England, this has contributed to a reduced rate of persons being imprisoned before their trial because they've been denied bail. Second strategy, making unacceptable risk the sole risk criterion when we consider bail. The Coghlan Review confirmed a 2-step process for assessing risk and expanded the offences that fall into the exceptional circumstances and show compelling reason reverse onus categories for bail. Yet the process is complex and cumbersome, with the same risk factors, what are known in the legislation as surrounding circumstances, being taken into consideration at both steps of the process. On the other hand, the Victorian Court of Appeal, the Victorian Law Reform Commission, and the Law Institute of Victoria have recommended that bail decision-making should be simplified and based on a single-step process with a single test: unacceptable risk. This would mean abandoning the complex 2-step process and the reverse onus categories that we currently use. This approach would not only simplify bail decision-making, but also avoid the breach of legal principle involved in those reverse onus provisions, which impose responsibility on the person applying for bail to satisfy the court why they should not be detained in custody. In conjunction with the use of actuarial assessment, this should be the way forward. The third strategy is using actuarial instruments to assist with risk assessment. Currently, bail decision makers are directed to take into account at least 31 surrounding circumstances when deciding whether a person applying for bail should obtain it. If either of the reverse onus tests apply, these 31 factors must also be taken into account when determining whether the person has established exceptional circumstances or has shown compelling reason as to why they should be granted bail. The Bail Act does not give any guidance as to how this information should be weighed and integrated in decision-making. In America, bail reformers in several jurisdictions have adopted standardised scales that assess risk. A person who applies for bail will be assessed on specified criteria and given a score. This score is then used to identify the level of risk if they are released on bail. I've previously mentioned the Public Safety Assessment Scale. It could be adapted for use in Victoria and could assist, not replace, simply assist, the police, bail justices, magistrates and judge who currently have responsibility for making decisions about bail to make better decisions. Running through all of this is a tension, though. Andrew Ashworth, writing in 2006, commented that assessing situations and persons from the point of view of perceived risk sits rather awkwardly with respecting the dignity of others as full rights-bearing citizens. So what we have to balance in future years is assessing risk when we're giving people bail or deciding not to grant bail against the traditional legal rights that we've invested in people. Which takes me to my conclusion. Denying bail and remanding accused persons in custody is our current strategy for protecting the community. We are seeking to reduce the number of offences committed by persons released on bail by putting more people in prison before their trial or the hearing of their matter. In essence, bail has become a tool of crime prevention. But this comes at a price: individual, social, legal and fiscal. It is presenting a major challenge to our prison service in relation to coping with increased numbers. While most people would accept that in a liberal democracy, pre-trial imprisonment through the denial of bail is sometimes a necessary evil, a new balance needs to be struck between the competing interests of protecting the community and that of keeping people being held on remand in prison to a workable and equitable level. An increasing remand population is not inevitable, and there are strategies that can be employed to reduce it, involving law reform, program and policy development, and a cultural shift in the criminal justice system. We should ensure that both short and long-term community protection are considered, and that only those persons who present a real risk of perpetrating serious offences are imprisoned before their trial.
Right. Well, thank you so much for such a thought-provoking presentation, Marilyn. It was really interesting to hear about that. We're going to start a discussion session in a moment now, so it's time for attendees to write any questions you might have into the question box on your screen and then submit. We'd love to hear from you, and we'll get to as many as we can in this session now. We do have a fair bit of time, which is great. So please do send them through. And we've had one come in from Glenn to start with, who asks, what percentage of people held in remand in recent years are subsequently found guilty and incarcerated?
It's a very good question. One of the real difficulties in relation to bail and the sorts of question you've asked is it's very hard to get data. So my answer to that question would be to refer to data that was presented to the New South Wales Law Reform Commission several years ago. It looks like most of the people who are charged with serious offences, so most of the people who are charged with serious offences and appear in our higher courts, the County Court or the Supreme Court, if they've been held on remand, they're subsequently found guilty and incarcerated. Where we get the biggest diversion is with people who are held or charged with lesser offences, offences that are heard in the Magistrates Court or the local court in New South Wales. And I cited for you there data that indicated that 42% of people who were on remand at the time of their hearing in the local court in New South Wales in one study were either not convicted or given a non-custodial sentence. So what we're seeing is for our serious offences, people have been held on remand, they typically are found guilty. Where we've got the biggest diversion is in relation to the relatively less serious offences which are heard in the lower courts.
Great, thank you, Marilyn. And we've had a few questions come through regarding the media's role in all of this. So thank you, Kirsty and Danielle. I'll try and paraphrase the two, but I think the general gist of them is about the moral responsibility of the media in terms of reporting on bail issues which have led to the perception of an unsafe community, despite the stats not necessarily backing this up.
I think these are really interesting questions, and they identify probably the most potent influence on recent legal developments in relation to bail. The idea that we are a community under siege, that crime levels are increasing, that community protection is best served by having more people denied bail and put in prison, I think has been run very strongly by some of the print media in Victoria. It has dominated debate, it's influenced parliamentary debate, and it really has dominated our thinking on this issue. It's very hard to get a positive story about bail if you go back through media reports in recent years. So in relation to both of you identifying the role of the media, I think it's absolutely critical. And the media reporting has been particularly one-sided. They were heinous crimes, the three offences in particular that I described, and you can understand they are the sorts of offences which do attract media attention, but they really, I think, have to be offset against where we are now. There's some recognition, I think, in print media in Melbourne at the moment that we do have a problem in relation to our prisons, that increasing prison numbers we can't keep on building prisons indefinitely, incarcerating people. But I think that what hasn't occurred is a frank acknowledgement of the link between denying people bail and the massive impact this has had, the pressure on our prison system. I think it'd be fascinating to see a study done on media reporting in relation to bail in recent years. I've got my impressions through obviously having looked at all of this, but it's not systematic. I would love to see someone do some systematic research about it, because I think we would find that there was an unusually uniform argument and a strong argument put by media, one outlet in particular, about bail laws being too lax, and this has driven the uptake of imprisonment pre-trial.
Thank you. A question has come in from Thomas, who asks, does CISP assessment prove to be an effective tool in assisting clients who have alcohol or drug issues for bail application?
I have another great question, and Victoria has some really good programs in relation to bail support services. What I would like to see happen is, I mentioned to you that we're spending ballpark figure of $1 million a day on these people who are detained in prison because they've been denied bail. What I would very much like to see is those people not detained in prison, many of them, and so much of that funding going to services like CISP and other bail support services, so that people who do have drug and alcohol problems, for example, which is related to their offending, can get those services while on bail in the community. I mentioned to you during the course of the presentation the number of women who are denied bail or haven't applied for bail and who are in prison in Victoria before the hearing of their matter. That, I think, is another interesting one that could be addressed differently. If you have half of those women not applying for bail, then I think it tells us something about the social difficulties that they experience, that jail isn't such a terrible alternative for them, that they are doing all that they can to prevent themselves from going for jail. So I think there it would be very good to direct some of those funding to provide support services for those women, be it because they're victims of domestic violence and they're confronted with a number of social problems related to that, be it because they have drug and alcohol problems or similar. What I guess I'm saying is I think that the programs that we have in Victoria are good, that I think that we need to support them even further. And one way we could do that is diverting some of that money we spend on keeping people incarcerated before trial.
Right. And thank you for that. There was a question from Glenn came in, who says he's surprised to hear actuarial risk tests aren't being used when assessing suitability for bail into the community. He mentions that these assessments have been used for many years in forensic psychology settings. I suppose it's a question of maybe why that hasn't been happening yet.
One of the reasons, I think, is that bail has been really low profile. You're right, we have lots of risk assessment tools that are used in forensic psychology in various stages. One of the things I think we should bear in mind is that bail hearings typically have been very brief. One of the things you might be following in the media at the moment is that the inquest into the James Gargasoulis murders has led to some controversy about what information was provided to the bail justice who released Gargasoulis on bail. Now, one thing I think is clear from that discussion is that the information that was available at the bail hearing was very limited, and that is very typical. Unlike some other points in our criminal justice system, bail hearings are typically very brief, and people comment all the time about how the information that's presented is inadequate. So I think what we need to do is take bail more seriously. After all, it can result, if you don't get bail, in someone being imprisoned, and maybe direct attention to it, like using actuarial risk assessments that we employ at other points in our criminal justice system. That would need a cultural shift, though. Really, we'd have to be treating bail and bail hearings much more seriously than we do now.
Glenn followed up, and I'm not sure what this specifically refers to, but he asked, is that due to confidentiality?
No, I don't think it's a confidentiality consideration so much. First, let's set it in context. In the past, nearly everyone who applied for bail got bail. What we're seeing now is a different, and it's a long-term trend, but we're seeing a lot more people being denied bail. So I think that why has bail been so unimportant in the past? Well, it tended to be a bit routine. People tended to be granted bail at a pretty early stage in the proceedings. So what we're seeing now is, I think, more attention being directed towards bail because more people are being detained. The cost of doing that, I'm hoping, will lead to more interest in things like these actuarial assessments, more attention, better decision-making in relation to who should be detained pre-trial.
We had a comment through from one of our attendees on the CISP program. This person is a case manager for the program who would suggest that the program involvement certainly assists, although they feel that some police and magistrate confidence in the program is at times quite low.
I think that's a great comment, and I think that most of the defence lawyers I speak to agree that they really value CISP and the other bail assistance and support programs. I think that they would also share the view that police in particular are often very sceptical about the value of those programs, but I think there is general recognition amongst defence lawyers that they really do contribute.
Right.
So I very much agree with that.
And a question from Kirsty who asks, what resources are currently available to people released on bail pending trial, aside from access to legal aid for the individual that still preserve their legal right to be treated as innocent until proven guilty?
I'm not sure. I
feel like maybe it was meant to be remanded. Oh, sorry, I'm not quite sure. Maybe if you'd like, we can come back to that.
Yes,
see if you could perhaps clarify that.
Yeah,
question.
I'm not quite sure what the question is there.
All right. We'll move on to the next one, and I'll see if Kirsty comes back to us. Vanessa asks, how can the community be confident that the steps taken in determining whether bail is granted are adequate in the absence of sufficient information about offending history?
Well, again, I think that's a very good question. And I think what we're seeing is because we now live in an environment where we're so attuned to community protection, the limited information that's still going through to bail decision makers is making them very cautious. And that's why we're seeing higher remand rates. It's not one other strategy might be to improve our decision making by getting better information through. And Justice Coghlan noted that in his report as well. So I think that we can't be confident that bail decision makers are making good decisions unless we're confident as a first step that they're getting good information coming through to them on which to base those decisions. So I think in the absence of good information coming through, limited information, what we've seen is this wariness, this fear of making the wrong decision that is really leading them to favour now denying bail and imprisoning people pre-trial. I understand the concern. No one wants to be the person who releases the next James Gargasoulis or the next Adrian Bailey or the next Sean Price on bail. I understand that. But the cost we're paying in terms of all those other people, those low-level offenders who really shouldn't be caught up in this widening net, is one that we should avoid.
And a question from Chloe that's come in follows on from that, who asks, does the growing concern in relation to family violence offending have an impact on offenders not being granted bail in these type of offences?
It certainly does. The reforms to the Bail Act make it mandatory now that when a bail decision maker is considering a grant of bail, they must take into account whether there's a family violence intervention order, where there is a family safety notice or domestic violence order out against the accused who's seeking bail. And that's, I think, a very good thing to take that into consideration. So I'm not saying that we should ignore those factors and release everyone, not at all. That's a very salient factor. I think that we are more sensitised to family violence. It is now something that bail decision makers must take into account as part of their decision making, and that's a good thing.
We do have a bit more time for some more questions, so please do send them through. There was a question from Lauren who asked, when was the last time someone was charged with treason in Victoria, and were they granted bail or not? And can you remember any cases where someone was able to go out on bail waiting for trial?
On treason?
On treason.
Lauren, you've just asked a question that intrigues me. The two categories, as you noted, where getting bail is most difficult, or traditional, and has been traditionally in relation to murder and treason. Murder cases, of course, occur all too frequently in Victoria. Treason, I'd have to say, I haven't looked it up. I haven't seen a case recently.
Nationally, not necessarily.
None of the terrorism cases that have come up in Victoria, to the best of my knowledge, have involved any charges of treason. But that lets me segue into that issue of terrorism. There are special provisions now in the Bail Act that deal with, not with treason, but with terrorism. And unsurprisingly, when there has been a terrorism record or terrorism information associated with the bail applicant, it's very much harder for them to be released on bail. But treason, I must admit, haven't seen it. I guess I should look it up and see when was the last time, but not recently is my guess.
Right. Thank you. I had another thought, which was just a query about if someone has been imprisoned before trial. Is there any research done or perception that might affect in the courtroom their ability to be judged presumed innocent, considering that they've been in jail?
Yeah. Well, one of the pieces of research I mentioned at the beginning is that if you are held in prison before your trial, you're more likely to plead guilty. You are more likely to get a custodial sentence. People might immediately say, oh, well, that's because we're actually putting the guilty people in prison before their trial. Well, research from overseas jurisdictions indicates that even if you control for other factors, those things, pre-trial imprisonment, itself contributes to people pleading guilty. People plead guilty because they want to get out of prison. You know, they want to minimise their term. They get a custodial sentence irrespective of matters really in relation to their guilt. So what I guess I'm saying there is that it's not just the system is functioning well, but people who are detained in prison prior to their trial do suffer significant legal disadvantages. They're more likely to plead guilty. That may be for a multitude of factors, including that it's harder to get access to your lawyer while you're in prison, and they do get custodial sentences at a higher rate.
Right, thank you. Now, we did have a clarification from Kirsty. It's rather long, but I'll read it out because I think it would be an interesting question to get to. So Kirsty says, what I mean is that there may be people who are released on bail pending a trial who have actually committed the crime they are charged with. However, there can be a multitude of reasons why someone has committed a crime which require addressing at a social services level. For example, a person who has been affected by domestic abuse might end up homeless, thus requiring them to take extreme measures to acquire resources such as money, clothing or food in order to sustain life. If this is found to be the case when considering releasing someone on bail, what resources are available for them to access the help they may need to improve their outcomes pre-trial?
Okay, it's a really good question. The first thing I'd say, Kirsty, is that the function of a bail hearing is not to determine whether the person has committed the crime or not. That's really clear. It's really, that issue has to be decided at the actual trial or the hearing of the matter. The purpose of the bail hearing is really simply not to consider whether the person's guilty or not, but rather should the person be released on bail. Now, as part of that decision making, I mentioned that there are 31 matters that a bail decision maker must take into account, described in the legislation as surrounding circumstances. Some of the matters you've mentioned as the sorts of pressures, being a victim of domestic abuse, for example, or issues of homelessness, poverty, are matters that a bail decision maker can take into account. The sorts of bail support services that we've mentioned before are there to assist people who have those sorts of disadvantages to obtain bail. In Victoria, we don't deny bail to people simply on the basis, for example, that they're homeless. And we have those bail support services to assist someone, a woman, for example, who's committed a crime because she has no access to money, because she's a victim of domestic abuse, can obtain some assistance to obtain short-term housing so she doesn't have to return to the dangerous environment, to get some assistance pre-trial. She can have those matters brought before the bail decision maker as matters that should help her to get bail. So I would emphasise first that it's not the task of the bail decision maker to decide whether the person is guilty or innocent of the charge, rather whether they should be released on bail or not. And some of the social and environmental circumstances that you've described, Kirsty, would be taken into account as part of that bail decision making process.
Great. Thank you very much. So that's all the time we have for questions, but please do, if you have more questions that come up, feel free to send them through to our alumni relations inbox and I can pass them on to Marilyn. That's deaconalumni@deakin.edu.au and it'll be shown on the screen in a moment. Thank you very much, Marilyn, for your time and for such an insightful presentation. It's great.
Thank you.
I'll run through a few alumni relations slides before I let you go and enjoy the rest of your day. So please do follow us on social media. We have a presence on Facebook and LinkedIn, and there's lots of great content available, so it'd be great to have you on board. Also, just a reminder to alumni that yourself and your immediate family are eligible for 15% off postgraduate course fees, which is a great opportunity. There's more information on the Deakin website, or you can email us at deaconalumni@deakin.edu.au. A reminder as well that we have a number of great competitions running throughout the year, usually promoted on our social media or through the Deakin Times e-newsletter, which comes out once a month. If you don't receive that, I encourage you to update your details with us so that you can stay connected and receive these communications and invitations to events near you. You can go to engage.deakin.edu.au or email us on our address there, and we'll make sure that you get all the communications. Thank you once again for joining us. As I mentioned earlier, a recording of the webinar will be available soon on the alumni webpage, and any feedback would be welcome. So please do just send us an email, deaconalumni@deakin.edu.au. We'd love to hear from you. Thank you and have a great rest of your day.